Welcome to the MyLawCLE presentation. During today's presentation, you may access the course materials from the handout section located on your screen. Attendees seeking credit for this presentation, pay careful attention to the screen. A pop-up box will be displayed at various times during the presentation. You will need to click Confirm on the pop-up each time it appears to qualify for CLE credit. In order to receive CLE credit, you must also click on the link that will appear at the end of this presentation to initiate the certificate process.
Good morning, everyone. Hope everyone is having a wonderful Wednesday morning out there. Let me introduce myself. My name is Ben Luftman, and I'm a founding partner of Luftman, Heck & Associates, and that is here in Columbus, Ohio. And I started my firm 18 years ago. And today I'm going to be speaking about handling a first OVI case, practitioner tips for a successful first phone call or interview. And so a little bit about myself. I went to Capital Law School and worked at the Franklin County Public Defender's Office and decided that I wanted to go and start a law firm right after graduating from law school, which I guess was a little bit unusual. But anyways, during that time, had the opportunity to go and sort of see the ins and outs of criminal defense and OVI law. And after starting my firm and during my career, have really taken a focus on OVI law. At this point in time, the firm has grown. I have 4 attorneys that go and work with me in the Central Ohio area, as well as one in Cincinnati that do criminal defense and OVI law. And at this point in time, for me, I take the calls, and anybody that's calling in on a first defense OVI, I go and speak with. So this topic is right in my wheelhouse, and hopefully want to go and share, my thoughts and experience, and help you guys out there when you get those calls to be able to better handle them, and hopefully the callers will go and retain you as clients, and at the very least certainly understand their situation a little bit better. I like to make it as interactive an experience as possible. Usually when I present, it's in front of an audience, so this is a bit unusual for me. But please, if you have any questions during my talk, please feel free to go and type them in, and I will look to go and address them to the best of my ability. So OVI, what is it? Ohio Revised Code Section 4511.19 states that no person shall operate a vehicle while under the influence of alcohol and or drugs of abuse on any public highway or private roadway in the state of Ohio. And so there are 2 types of OVIs. One is the OVI impaired, which is the officer's subjective opinion of how you were driving, how you pulled over, how you looked, how you smelled, what you said, and how you performed on the roadside field sobriety tests. And then there is the OVI per se, which is taking a chemical test, blood, breath, or urine, and testing above the limit. In my experience, and I'm assuming probably most of you, the breath test is the most oft given test, so that's the one I will go and sort of talk about the most during my presentation. So ultimately, you go and get the call, and the person on the other line is going and now facing their first offense OVI. And I can tell you from taking thousands of these calls, literally, how is the person? How is the caller? They're scared, and they have no idea what's going on. There are multiple issues that they're likely now facing. They don't have their driver's license. They don't know how they're going to go and get back and forth to work. They don't know how they're going to go and drive their kid to school. They don't know how they're going to go to the grocery store. They don't know if they're going to go and continue to maintain employment. They're embarrassed, and basically the world is crashing down around them, and they're looking to you. They're looking to you to go and provide some clarity for them, and to go and help them understand and navigate a very confusing situation. So, there are many moving parts to an OVI, and, again, generally the caller has no idea what's going on. And I think the first thing, and one of the most important things, is your demeanor. How do you carry yourself during that phone call? I think that the most important thing is to be empathetic, to really go and empathize with what the person is going through and how many layers they're trying to go and unpack at this point in time. And I also think it's important to be understanding. You know, they don't know. And, the way that you go and explain things, you have to go and try to synthesize or make it as simple as possible because, again, a call will take 15, 30, 40 minutes. And I guess I'll back up. You could take a call and try to schedule it for an interview in your office, or you can go and just take the call. I can tell you that for me, in my experience, I generally go and do most of the first time as a call and not an in-office interview for a couple of reasons with respect to the OVI. Number one, because the caller generally doesn't have a license at that point in time. They might have problems getting back and forth to your office. And number two, I think things have changed really in the practice of law. I think that making things as easy as possible on the caller or potential client is what you try to go and do. And I think that you do it from the very outset. So if they don't have to come to your office, if you can go and take a call or do a Zoom call where they don't have to come to you, I think that that's appreciated by them. And again, in my experience and practice, is definitely most oft used for that first time. So you really have to go and be understanding with respect to their needs at this point in time. And so, when you go and you get into this call, there's some background work I think that everybody should go and do. So when you go and take the call, that you know what you're talking about. And the person, again, they have no idea what's going on, and they're looking for you to go and give them clarity and to go and give them game plan, to give them a roadmap and hope, if hope is out there. And so, I think you need to be informative. And I will say this, because I've talked to so many people, every person, I think the average is that they call between 4 and 6 attorneys when they're looking for representation. I mean, that's a lot of people. Quite frankly, I think it's too much. I think you get paralysis by analysis. But be that as it may, I hear from people all the time that the attorney just wanted to go and quote them a fee and just go and sort of get them off the phone, and they could either do it or they couldn't. And they didn't want to listen to their story, and they didn't go and provide them with information on their situation. So I think that being informative, just generally speaking, is incredibly important. For example, I think that you need to know the lay of the land in the court or courts that you go and practice in. Who are the judges and prosecutors? Does the court do stays of the administrative license suspension? And we'll discuss stays here in a little bit. Do they grant driving privileges? Do they have their own forms to go and do so, or do you have to file a motion and proposed entry on your own? Most importantly, does the prosecutor offer reductions on OVI cases? So, if you don't know that, take the time to do it. Go over to the court, talk to the people there. If you have other attorneys that you go and know in your area that practice in that area, and that's something that you're interested in, and obviously you are if you're watching this presentation, go and talk to them and get the answers to those questions. Because again, if you're able to go and tell them, who the prosecutors are, who the judge is, then the caller is going to think that you have familiarity with that court, and you're going to start to build that trust. And at the end of the day, from a practitioner standpoint, I mean, you want the caller to become a client. You want them to go and pay you to represent them on these cases because it helps your bottom line. And so, with that in mind, that type of initial familiarity with the court and their practices, you're going to go and give that caller the confidence that they need to go and have in you, or at least begin to, while you're going and making the call. And so with respect to OVI cases, really there's two approaches that you can go and take, or that a person can go and take in an OVI case. First, the individual is not concerned about having the OVI on their record. Their concern is that they want to try to get the minimum penalties. They want to try to avoid jail time. They want to try to avoid probation. They'd like to go and get the minimum license suspension and the maximum driving privileges that they can go and get. The second approach is that the individual is concerned about having an OVI on their record due to its potential impact on their current job or a future job, or perhaps immigration purposes, or psychologically they can't deal with having the stain of a drunk driving conviction on their record for the rest of their life. So during this initial call or meeting or interview, you need to go and explain to them everything, right? And be as detailed as possible, answer their questions, and ultimately figure out what the potential client goals are. And, given the approach, it's going to guide how you handle the case, what you go and do with the case, and presumably your fee as well. And with respect to the fee, in addition to going and sort of knowing the lay of the land of the courts you're in, I think it's important to know what people in your area charge. Attorneys in Columbus charge a different fee than attorneys in Cleveland potentially, or in Cincinnati, or everywhere in between. So I think that in setting your price with the goal to ultimately convert the caller into a client, I think that you have to go and know what the general fees are in your area so that you set your fee in that area. I think that's very important as well. So, before you can go and give your assessment, your professional assessment, you need to know what happened from the caller's perspective. So again, in understanding their situation and again being empathetic to their situation, they want to go and be able to go and tell you their story, and you need to go and make sure that you listen to it. So you need to make sure that you get as much detail from them as possible. How much had they been drinking, or if they were using drugs, what, marijuana, for example, I would say is the most common drug I see. Are they an everyday smoker? Did they smoke 2 hours beforehand? Over what period of time, obviously? When did they stop drinking or using drugs? Potentially their size and weight for alcohol, to go and try to determine what their BAC might have been if it's a urine test. What type of law enforcement officer stopped them? And that's important because, Ohio State Highway Patrol are all equipped with a CVS, which is a cruiser video system. And so automatically that there's going to be a DVD. So when you're talking about the discovery, which we'll get into here a little bit later, you'll know that there's a DVD. Or if it's a sheriff's deputy, most of them have body cam at this point in time. And, some of the local municipalities have them and some don't have them. So that's an important thing to go and find out. And why were they pulled over? Was it some sort of moving violation? Was it an equipment violation? Were they actually stopped? That could certainly guide your assessment of their case. Were they asked if they'd been drinking or ingesting drugs? Did they go and admit? Did they say how much? Did the officer do the roadside field sobriety tests? And if so, which ones did they go and do? And there's a main battery of 3, and we're going to go and get into that here shortly: the horizontal gaze nystagmus, the walk and turn, and the one-leg stand. But they also have a number of additional tests that they can go and use: the backwards number count, the alphabet test, sometimes the finger to nose tests. They can go and do those as well. So you need to go and get very detailed information on that, in addition to going and figuring out how did the caller feel that they performed on those tests. And usually they go and give you an honest assessment of that. So in regard to the standardized field sobriety tests, we're going to talk about those a little bit, because again, when they're telling their story and they go and tell you about what happened and they go and inevitably get into the field sobriety tests, you want to go and pay particular attention to that. So just a little background on those standardized field sobriety tests. They were developed by the National Highway Traffic Safety Administration, or NHTSA, in the 70s. And basically, NHTSA was funded by the federal government at that time, and they said, you need to go and develop a manual that law enforcement officers can go and use across the country so that they can go and uniformly determine whether or not an individual is too impaired to go and drive. And if you're really interested in this type of practice area, you can potentially go and attend a seminar where you can do the same training and go through the NHTSA training and get certified in the administration of the roadside field sobriety tests. I did that, and the other attorneys that work with my firm did that. And if you're going to be a serious practitioner or really interested in this, I would highly advise you consider going and attending that as well. And you're certainly more than welcome to reach out to me, and I can provide you with information. And for that matter, if anybody has any questions after the presentation in regard to anything practice-wise or business-wise or sales-wise, you have my contact information. Please feel free to reach out. I'm always more than happy to go and talk shop with anybody, and so I would encourage you to do that. But getting back, so I went to this seminar, and so the field sobriety tests that were used prior to the NHTSA manual being made were across the board. For example, a couple of them, one was a change test, and an officer would go and stop somebody and get them out of their car, and they would take a bunch of change out of their pocket, and they would throw it on the ground. And they would instruct the driver to go and pick up the change from the smallest denomination to the largest denomination. And if the driver was somehow simultaneously able to go and pick up the change in the correct order and not fall flat on their face, they might let them drive home. Another test that they went and did was a signature test, where they would go and have the driver sign their name in a box multiple times. And if they were able to go and keep their signature in the box, again, they might let them drive home. So an upgrade was needed. And so NHTSA was funded with millions of dollars from the federal government. And what they did was, mostly in California, I believe, they had a lot of people come in, and they would have them drink to varying degrees. And law enforcement would go and do a number of tests on them. And they would go and score those tests. And then they would have the person come up, and they would go and do the breath test. And then they would chart the BAC results. And so through a process of doing this thousands of times, they came up with this manual, a couple hundred pages. And so basically, this manual is the guidebook, and it's taught to officers while going through law enforcement training. And it's used to subjectively determine whether or not the driver is too impaired. And again, any OVI practitioner needs to familiarize themselves with these tests, because during the initial call, it will help you in your decision with the potential client, on which way to go, and also understand what they are trying to relay. And you can point out that officers, they do make mistakes in going and administering these tests. So if the caller is interested in fighting the case, you can tell them that, basically that the way that you go and get a reduction or a dismissal is to find the flaws in the case and to go and point them out to the prosecutor. How did the officer go and make mistakes when they were administering those tests on them? And if the prosecutor is not willing to go and reduce the charge and the goal is a dismissal, the only way to fight a case properly is to be able to argue effectively and neutralize the case before a judge or jury. And so I think that reviewing and familiarizing yourself with the NHTSA manual is very important. I've included a link there. Hopefully they'll have that. If you're not able to go and find that, again, please feel free to reach out to me. The Washington State Highway Patrol, I believe, has it on their website. It's free, and I would strongly encourage you guys to go and take a look and or print it out, because if you're going to do a motion hearing, you want to have that with you to go and cross-examine the officer. In addition, I've included a probable cause checklist in the course material that I've provided for you guys, and that basically synthesizes the NHTSA manual basically down to its essence, and all the cues or clues that you would need to go through and check off and figure out what was done properly and what wasn't done properly. And so with respect to going and dealing with that in the NHTSA manual, and if you're looking at the probable cause checklist, if you can go and pull that up, basically there's 3 phases to an OVI arrest. There's the vehicle in motion phase, there's the personal contact phase, and there's the pre-arrest screening phases. And during each one of these phases, the officer is taught that there are certain cues or clues that they would go and look for. And if they go and see them, they're supposed to go and note them in basically determining whether or not they're going to arrest the caller for an OVI, and also to use to refresh their recollection should they be called to testify about that at a suppression hearing, which we'll get into a little bit later. In addition, that's the main bulk of the evidence that a prosecutor potentially is going to use to go and obtain a plea or a conviction. And so I can tell you in my experience, usually in the vehicle in motion phase, there's 4 types of offenses that I see most often cited for going and pulling someone over. One is a marked lanes violation. The second is a speed. The third is an equipment violation. And the fourth is an accident. And so, in having them go and explain their circumstances and the events in terms of what was going on, they'll go and explain that to you, and you'll go and figure out whether or not what happened to them or why they were stopped, fits into that. And you can go and talk about that. And when you're going and doing that, you can point out to the caller, so the second phase of the stopping sequence, how did they go and stop? Did they pull over appropriately? Did they go and follow the officer's orders? Because ultimately the stopping sequence in the NHTSA manual, they're taught to go and look and pay very particular attention to going and dealing with it, because they're taught in the academy, look, there are 2 ways that people go and function. There's a psychological component and a physical component to driving, right? You have to understand and appreciate what's going on around you. And physically speaking, your body has to be able to execute the commands that your mind is telling it. So if someone is under the influence of alcohol or drugs, generally speaking, they have one of 2 issues, either psychological or physical. So everything that happened from the time that the officer turned on their overhead beacon was designed to go and determine whether or not that caller that you're speaking with is too impaired to go and drive. And you can go and point that out to them. And so you move on to the second phase, the personal contact phase. Basically the officer is taught to go and use their senses, their sense of sight, their sense of hearing, their sense of smell when interacting with the driver, to go and further determine whether or not there are cues or clues that could indicate that the driver's impaired. So was there an odor of alcohol? Was there an odor of marijuana coming from the vehicle? Those types of things would be clues or indicators that potentially they're too impaired to go and drive. And you can also look a lot of times on the BMV Form 2255, which I'll get into in the B section there, pardon me. They go and list their reasonable grounds for arrest. You can go and look at that as well. And the last phase is the pre-arrest screening phase. And in the pre-arrest screening phase, that's where they're going to go and do the roadside field sobriety test, standardized field sobriety test, commonly called roadside field sobriety test. Most common ones are the horizontal gaze nystagmus test, so the eye test, the walk and turn test, and the one-leg stand test. And so with respect to going and dealing with it, you can ask them to describe how those tests were done. Obviously, they're supposed to go and keep the stimulus 12 to 15 inches away from the person's face and slightly above eye level. So you can ask them, did they go and do that test? Was it right up to your nose? And you might potentially know initially that there are some issues with it. I would say in my experience that the horizontal gaze nystagmus test is the most often messed up test by the officer, and you need to go and pay particular attention to how they're going and doing that. So when they're going and doing the test, there are 6 clues, 3 clues for each eye, and if they see 4 or more of those 6 clues, there's a 77% probability that the individual would test above the limit. And so I really tell you to go in and check out the NHTSA manual for that. The walk and turn, the one-leg stand test, both are supposed to be done on a relatively smooth, flat, dry, level surface. And so it's important, or did they do them on a grade? You can ask when they're going and telling the story, did they do them in gravel? No, they're supposed to go and do all of it on a relatively smooth, flat, dry, level surface. And again, they're supposed to give the demonstrations and instructions properly as well on both of them. And ultimately, when you're going and talking with them, you need to get those details and have them tell you about those field sobriety tests, and then sort of cross-reference the NHTSA manual or your probable cause checklist to go and know whether or not they did those properly and give them an assessment of what your thoughts are. I mean, overall, again, the conversation that you have with them is, if you want to go and fight these cases, you have to go and find the flaws with those cases. And again, I can tell you guys and gals from my experience, generally speaking, they make mistakes. This isn't rocket science, but I see it happen over and over again, and I've been doing this for 18 years. My firm has been privileged enough to represent literally thousands of clients in over 65 counties and hundreds of courts across Ohio, and I can tell you that they always make mistakes. I mean, very few officers are perfect. And again, if you're doing this seriously and you want to go and try to do the best you can for the caller or your potential client, you have to go and know these things. And again, ultimately in guiding them in making a decision whether or not they want to go and resolve the case and just try to minimize the penalties or actually go and fight the case, it's important that you go and know these details. And I will say this, in terms of going and making that decision, I have a rule of thumb that, if you're a professional or if you have professional aspirations, I think it's important to go and try to fight the case. And I'll tell any person that contacts me that that's my professional opinion, regardless of whether or not they hire my firm or somebody else. Really, really important, because at the end of the day, these OVIs have life consequences, and they can go and distinguish the caller negatively, and you need to go and make sure that they go and point that out, or you point that out to them. So let's talk about the administrative license suspension, because clearly the caller, again, when they're calling into you, their license is likely going to go and be suspended at that point in time. They're freaked out, they can't drive, they don't know what they're going to go and do, and you have to go and guide them through that. So if you fail the chemical test, again, blood, breath, or urine, initially through the Ohio BMV, your license is suspended for 90 days. And the first 15 days is a hard time suspension, where you're not supposed to be eligible for driving privileges for the first 15 days from the date of the offense, but afterwards you are eligible for limited driving privileges. We'll talk about that. If it's a chemical test refusal, that suspension through the BMV is 1 year, and you are ineligible for driving privileges for the first 30 days from the date of the offense. And so the practitioner note that you see there, I think it's always important to go and ask if they were given a copy of the BMV Form 2255, that yellow sheet of paper, and you would ask them to go and send it to you, take a screenshot and text it. Most people have smartphones, and they're able to go and do that, or sort of go and guide them through it, because there are potential issues that you can go and spot on that 2255, where if you go and do that, they might be able to go and either continue to drive or get their license back sooner rather than later. And again, for you, it's important to go and explain that to them so that they go and understand their situation better. But also from a sales standpoint, you want to bring value. And if you're going and bringing value and pointing out what those issues are initially with respect to their license suspension, which is their immediate concern, I mean, it's their first concern without question, then again, it just builds confidence in you that you know what you're talking about, that you can bring them value, and that you're going to go and be an asset to them in representing them on the case. And so again, there's a couple different ways that you can go and approach the license suspension issue. One is to go and request a stay of the administrative license suspension. And again, in doing your due diligence and doing your homework on your jurisdiction, you need to know whether or not it's a place that allows stays. And again, the process of requesting a stay, generally a stay would be requested during their initial court appearance, which usually obviously is within 5 business days of their traffic stop. And if the judge stays the administrative license suspension, they will have their full license back immediately. So they'll be able to go and drive without any restrictions or limitations on where and when they can go and drive. And in terms of a practitioner standpoint, I always go and make sure that we get 2 certified copies of the stay if it's granted. And one of those copies I want our clients to go and keep in their car at all times. And the other is they will take that to the BMV to get their replacement physical license. And the reason why that's so important is, and I've seen this happen, so your client gets a stay granted, and the clerk's office is supposed to go and forward it over to the BMV, or the client takes it over to the BMV themselves, and they go and get the replacement license. And for whatever reason, it doesn't get entered properly into the system. And so they could be driving around and think everything is great, and I'm able to drive, I don't have any restrictions, I'm back on the road, thank goodness, deep breath. And then for whatever reason, they go and get pulled over by a law enforcement officer. And the law enforcement officer goes and runs their license, and it's still showing as suspended. And they're like, no, 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 I have my license. I went to the BMV. I got a stay. And they're like, well, not in our system. And then potentially they run the risk of being arrested, again, having their car impounded, and having to go and face a charge of driving under administrative license suspension that carries mandatory jail time, mandatory 3 days for that. So knowing those issues and mitigating those issues, you would always want to go and get 2 certified copies, one that they would keep in their glove compartment as well. So if that situation did arise, they would be able to go and have a certified copy signed by a judge in their vehicle to go and present to the law enforcement officer. And that would hopefully help them mitigate that situation, being able to see that signed and certified court document. So very important. Practically speaking, I think stays are especially good in refusal cases. Again, where you have a 30-day hard time suspension, as opposed to where you take a failed chemical test where it's 15 days. And I always ask the client when I'm going and sort of explaining their options with respect to this, can you tough it out for 15 days? If so, great, we can get the limited driving privileges, and after 90 days, potentially they get their full license back. If they can't go and do that, or if the license suspension, is for a refusal, which is 30 days, it's a bit more difficult to go and manage. And so you need to make sure when you're explaining this, so the benefit obviously is that you would get your full license back immediately, but it basically puts the suspension on ice or kicks the can down the road. And so clearly the goals when you go and deal with these cases usually is to go and try to negotiate a reduction of the OVI to a lesser offense. And generally in Ohio, there are 2 lesser offenses that a prosecutor will go and amend an OVI to, and that would be a reckless operation of a motor vehicle or a physical control of a motor vehicle under the influence charge. And I guess just a little bit about that. So the reckless operation is a non-alcohol traffic offense. Generally speaking, it's a 4-point violation. The physical control is a 0-point non-moving violation, but it is alcohol related. It's physical control of a motor vehicle while under the influence of alcohol or drugs, 4511.194. And so I guess practice tip, if you're going and negotiating that type of reduction, it really depends. If you have the option outside of a driving job, I think a reckless operation is a better reduction because it's non-alcohol related. If the person drives and they have a commercial driver's license, definitely want to go and try to negotiate the physical control. The good thing about either of those offenses is there is not a mandatory license suspension upon conviction. So when you go and deal with the case, the goal, in addition to reducing the charge, is to try to reduce the length of the license suspension as well. And so for an OVI conviction, obviously it's 1 year minimum. And so if you can reduce it to 6 months or something less, that's the goal. You want to go and try to minimize it all the way around. It's collateral benefit. So if the person has a stay and there's any license suspension, the license suspension is going to begin from the day the case is over. And so if you're able to go and get a reduction and they go and terminate the license suspension ultimately and give a court suspension, then they're not going to have to do the 15 days or the 30 days of the hard time. They could go and potentially roll through having their license into going and having limited driving privileges, which again is another benefit. If they're not willing to go and do that, then whatever suspension they have is going to begin, after the case is over, and they're going to have to go and serve that. Whereas if they get the limited driving privileges, that's for 90 days. And if a case takes, 4, 5, 6 months, then potentially you're going to go and get credit for that extra time after the 90 days, even though the case is going over. So they might have a very minimal suspension after the case is over. So with respect to limited driving privileges, again, If you fail the chemical test, you're eligible for limited driving privileges after 15 days from the date of the offense. Refusal of chemical test, 1-year suspension, eligible for limited driving privileges, 30 days from the date of the offense. And requesting limited driving privileges is an alternative to requesting a stay of the administrative license suspension. And so as opposed to the stay, which gives you your full license back with no restrictions, the limited driving privileges are limited to educational, vocational, and work-related activities. Medical needs are generally granted as well. So in doing your homework and due diligence, different courts are more and less flexible with driving privileges. For example, some courts allow driving privileges for childcare needs and others do not. Some courts allow driving privileges for household needs and some do not. Especially with respect to that, if people have kids and the court doesn't go and allow driving privileges, and there are some here in Central Ohio that don't, then you need to go and know that and be able to go and point that out to them so that they know and aren't planning to go and get something that ultimately they're not going to go and get and can go and make other arrangements. Really important to know that. Some courts have their own limited driving privilege form, and some require a motion and proposed entry. And it's important to know how each court or judge deals with limited driving privileges in order to avoid delay in filing. And I will say this, some are very quick in going and getting those reviewed and signed, and some are not very quick in getting those reviewed and signed. And so I think when you're having the initial caller interview, telling the caller if they're going for the driving privileges that you need to get all of their information in terms of their work, in terms of all their limited driving privilege needs, and please be as detailed as possible, as quickly as possible, so that you can go and get them filed on their behalf to avoid any further delay. And again, looking to go and try to show value to them and making sure that their needs are met and they're able to go and try to get back to some sort of semblance of their normal life as quickly as possible. Practitioner tip, always make sure to confirm the caller has insurance and get a copy of the insurance card to provide, if necessary, with your driving privilege motion or application. So some judges and courts, they note whether or not financial responsibility was shown on the actual ticket itself, go and accept that. Others want to go and see a copy of that card, specifically noting the length that the insurance coverage provides for, and you need to make sure that you have that and are able to go and provide that, because you don't want to go and get privileges for someone that doesn't have insurance and have them driving around on the road out there. No, that's not a good situation, so make sure that you go and get that. So in your initial caller interview with the person, you can note that you can appeal that license suspension. And a lot of times what I go and see, I'll read this and say what I go and see. So pursuant to Ohio Revised Code section 4511.197, an administrative license suspension may be appealed at the initial appearance, which is at the 5-day hearing or within 30 days of the same. The scope of the appeal is limited to determining whether one or more of the following conditions have not been met: whether the officer had reasonable grounds to believe the person was operating a vehicle under the influence or after underage consumption or in physical control in violation of statute or municipal ordinance, and whether or not the person was in fact placed under arrest, whether the officer requested the person submit to a chemical test or tests, whether the officer informed the person of the consequences of taking or refusing a test or test, and whichever the following is applicable, if a test refusal suspension was imposed, whether the person refused to submit to the test or test required by the officer, or if a failed suspension was imposed, whether at the time of the offense the bodily substance contained a prohibited concentration of alcohol or a listed controlled substance or metabolite. And I can tell you guys that, in terms of going and dealing with it, what I see most times people go and say is that the officer did not go and read the information in regard to the consequences of taking or refusing a test, the boilerplate language on the back of the BMV Form 2261, and whether or not they actually refused to go and take the test. And quite often I'll hear people go and tell me that I didn't refuse to go and take the test. They gave me the instructions, I blew as hard as I possibly could, and it didn't come up with a reading. I don't understand this. And again, being empathetic, I believe that absolutely happens sometimes. Practically speaking, what they're going to go and say is that you didn't go and provide a sample sufficient to go and get a test result, and that you were going and sort of, manipulating the test. That's what's going to be their argument, and you can go and certainly have a hearing on it in front of the judge and go and argue that, and the judge will go and make that determination. But frequently, that's what I go and see most. And so, talking about the BMV Form 2255, which you guys have in your course material. I don't know if you can go and pull it up, but it's the form that's used by the BMV and law enforcement to suspend a driver's license based on a failed chemical test or refusal in an OVI case. Again, I think it's extremely important to go and review the caller's 2255 to see if there are any potential error or errors on the face of the form that could allow them to potentially go and keep their license. And from a salesmanship aspect, if you are able to see errors and point them out to the caller, again, you're showing your knowledge and adding immediate value if you're indicating that it might be possible to get their full license back, and providing them with a little hope in the meantime. And so in my practice, one of the most common errors that I go and see on the BMV Form 2255, if you're looking at it, is that in the B section, the fourth box down, there's a box that says was placed under administrative license suspension, 4511.191. And so oftentimes I will see if an officer's in a hurry, or they don't really, maybe they're new, they don't really know what they're doing, don't know how to go and fill it out properly, they will leave that box unchecked, which initially is potentially a big deal to the caller. And I'm going to go and point this out to them and say, look, it's unchecked. And so I need to go and check the copy that's in the court file as well and see if it matches up. Because one of two situations are going to go and happen. One, they leave it unchecked and unaltered, and that's in the court file, and that's potentially what's sent to the BMV, and it doesn't note that the caller or the driver, potentially your client, is under an administrative license suspension, and they can go and continue to drive. The second is that they will go and actually check that box after they've served it on your client, and then they will go and submit that to the court. And that's a no-no. You cannot materially once going and serving it upon the driver. And so if they go and do that, and you go and point that out, that's something that could potentially go, or should potentially go, and initiate a termination of that license suspension due to the alteration. So the BMV Form 2261, which again should be in your packet of information as well in the course materials, if you can go and pull that up. This is the main form that you will go and use, and that I was referencing during my talk about the stay, to go and allow the driver to get their license back. So it's used for both to stay and terminate the administrative license suspension. And so the first box or the first set of boxes, pardon me, if you're looking at, is talking about terminating the license suspension. And if you read through them, the appellant's appeal was granted upon the court's determination of one of the more following conditions: that the law enforcement did not have reasonable grounds to believe that an OVI violation occurred. The officer did not request the appellant to submit to the chemical test. That the officer did not inform the appellant of the consequences of a refusal or submitting to the test. That the appellant did not refuse the test, or that the test results did not indicate a prohibited concentration of alcohol or controlled substance. There are some additional factors there. The officer did not place the appellant under suspension. The BMV Form 2255 was not filed with the court or was not sent within 48 hours of the offense. It's difficult on that one, but that's definitely an issue that comes up as well. The BMV Form 2255 was completed improperly. That's what I was referencing in regard to the officer not checking that box and then going and altering it afterwards. Test was not administered within the 3-hour time limit. They have to go and ask you to take a test within a certain period of time, and you have to physically take the test within 3 hours of the time of the offense, 2 hours to ask you to take the test, and the initial hearing on the ALS was not held within 5 days. So all of that could be used as possible reasoning to go and terminate the license suspension. If you scroll down a couple more boxes, the stay of the administrative license suspension was issued, so that's the stay that I was referring to. And so if you look further down, there's signature boxes for both the prosecuting attorney and for the judge. And the prosecutor can sign that, or they can quite frankly object to the staying of the license suspension. So again, knowing the judge that you're in front of, it's important to go and know whether or not they would go and grant it, because at the end of the day, at least with respect to this, the judge can go and grant the stay over the prosecuting attorney's objection. And some judges will and some judges won't. So you need to make sure that you know if your judge will or won't, and going and discussing that with the caller or your potential client. So one of the things that you need to go and talk with them about is the discovery process. And you need to let the caller know that you will go and file a discovery demand, in addition, quite frankly, to a number of other documents that you would go and initially file in the course materials. I went and provided you with a sample of our packet that we go and file at any time, and please feel free to go and peruse that. The discovery request or demand is in there. And so you need to let them know that you will file a discovery demand to get access to all the information available, and most important, we'll provide a copy of all of that to them to go and review. Well, what's included in OVI Discovery? The officer's narrative, the alcohol influence report that deals specifically with how the caller performed on the standardized field sobriety test, a DVD potentially. Again, you got to know what the jurisdiction is of the officer that went and pulled your client over. Some have them, some don't. And information regarding the breath test. So some jurisdictions and prosecuting attorneys provide that information as part of the discovery, and some do not. I think it's important that even if it is provided, that you should make an appointment with your arresting agency, to go out and look at their logbooks and see whether or not the officers were properly certified and whether or not the calibrations were done timely. They're supposed to be done every 7 days and 192 hours for the most part, before and after your client's arrest. And so I would go and ask someone who has represented plenty of people on OVI that you trust, their knowledge and experience, to potentially go and take you out there. I was fortunate enough to have a mentor when I was starting my practice, and he did many OVI cases, and he took me to the Ohio State Highway Patrol with him, and he sat me down and he showed me everything he was going in and looking at, and it was good to be in there, and it was good to be in the BAC room and see the breath test machine, so you can sort of get a sense of what the caller is going through, and as you're going and looking around. So I think it's important to familiarize yourself with respect to that. So definitely go and make an appointment to get out there and check out the calibrations and the logbooks and the machine itself. So let's talk about the penalties. Everybody wants to know, what are they facing, right? So the penalties for an impaired or low test first offense, it's a first-degree misdemeanor. It's a mandatory minimum of 3 days in jail or a 72-hour certified job intervention program, up to 6 months in jail. The mandatory minimum fine is between $375 and up to $1,075. And the judge could go and give additional treatment. It's optional, but not mandatory required. Upon conviction, the driver is eligible for limited driving privileges after 15 days from the date of the offense. That may be reduced by half with unlimited driving privileges. And restricted plates, the yellow plates, the nasty yellow plates with the burgundy trim that say I've been convicted of a high test OVI, or possibly I'm from New Mexico if you don't know any better, are optional in that. And the interlock, the breath test device, is mandatory for unlimited driving privileges. And so with respect to the unlimited driving privileges, you can potentially go and cut the suspension in half with those limited driving privileges from 12 months to 6 months, but you have to have the interlock breath device installed on your vehicle. First offense penalties for a high concentration, either alcohol or drugs. It's first degree misdemeanor, again, mandatory minimum 6 days in jail or 3 days in jail, in addition to the 72-hour drug intervention program. There is a mandatory minimum fine of between $375 and up to $1,075 fine. Additional treatment, again, optional. The caller is eligible for limited driving privileges 15 days from the date of the offense. Again, may be reduced by half with unlimited driving privileges. The yellow plates are mandatory for high concentration convictions. The interlock mandatory if you're going to go and try to get unlimited driving privileges. Obviously, with respect to this, when someone is charged with a high test, usually breath test, they do not want to go to jail, and they do not want to go and have those yellow plates on their vehicle for a year and have to suffer the embarrassment of driving to their job or carting their kids around. Don't want it. And so their goals, without question, if you get someone who contacts you with this situation, is, am I going to go and be able to avoid the mandatory jail time? Am I going to be able to go and avoid the yellow plates on my vehicle? Again, sort of knowing the jurisdiction, important to know whether or not, some will go and get rid of the high test fairly readily, and others are going to fight you tooth and nail. And you got to know what the lay of the land is so you can go and accurately advise the caller of the potential to go and do that as well, and what it's going to take. So in explaining the court process, an important part of the consultation with the caller will be to explain the process going through an OVI case. And the process and explanation goes back to what the caller's goals are with respect to the case. If they want to fight the case, they need to know what they're getting themselves into, right? If the client is not interested in fighting the case and is only interested in minimizing the penalties, you will need to explain what those minimum penalties are, and that depending on the court, it can take 1 to 3 court dates to go and resolve. And this will be done strategically to best minimize those penalties for the client. For example, if a court does not put a client on reporting probation, if they complete a driver intervention program and have no further follow-up recommendations, it might make sense to enter a plea and set it for a sentencing hearing that will allow the caller to complete and avoid. Nobody wants to report to a probation officer once a month for a year. If you can avoid that for them, and all they're interested in doing is minimizing the penalties, you want to do that, and you want to let them know that you're going to go and do that if they go and retain you to represent them strategically. If there was an accident with another vehicle, restitution might need to be verified before you can resolve the case, and the victim would potentially have an opportunity to be heard at sentencing as well. So it might take multiple court dates to go and do that, even if they're just interested in going and resolving it. If the caller is interested in fighting the case and trying to get a reduction or a dismissal, it's imperative that they know what they're signing up for, and that the process will generally take 3 to 6 months. And so the arraignment process, will you need to appear? Will the client need to appear? Does the court accept facts filed not guilty pleas or as placeholders, and then you have to go and mail the original? Will you be able to go and get a stay? Will you file for limited driving privileges or wait until assigned to a judge? What documents will you be filing on a client's behalf? The not guilty plea, obviously. Demand for a jury trial needs to go and be filed. Got to make sure that you go and do that. If you don't, you could waive it. Notice of appearance of counsel. Demand for discovery. Motion to preserve evidence, primarily the DVD of a traffic stop, and the administrative license suspension appeal. Again, you should have that in the course materials, everything that we go and file on our clients' behalf in these cases. So please feel free to use that. And you have my permission if you have any questions or anything. Again, please feel free to go and reach out in regard to that. But it's important, right? Again, getting back to, you want to go and try to make things as easy on your potential client as possible. If you can spare them having to go and take time off of work to go and come to court, well, that's great for them, and they're going to go and appreciate that and appreciate you for going and doing that. And on your end, if you're able to go and avoid having to go to court at the arraignment, well, you're going to be able to go and focus on other things, and that it maximizes your time, which is certainly what you want to go and try to do in your practice, so you can be focusing on other cases. Pre-trial. First opportunity to discuss the case and negotiate with the prosecutor, generally scheduled 30 days after arraignment. And ultimately, are you able to go and waive your client's appearance at the pretrial? Are you in a court that only addresses driving privileges at a pretrial, so you have to go and do them at that time? Will you have to go and discuss potential issues for a suppression hearing with the prosecutor and or judge on that date? You have to go and do that. You want to be prepared. And are you able to do a Zoom or telephone appearance? Again, trying to make things as easy as possible on yourself. If you're able to do that, we always ask. And particularly during the pandemic, a lot of courts switch to that and still do that, which is fantastic. You don't have to drive to go there, and you're able to do it from your office. Well, that's great, and you need to go and find out and make sure that your client knows, and especially if they're calling you from out of state as well, because of the time and money that it takes to go and do that. Can you file a motion to waive their appearance given that as well? Something you definitely want to go and check into and know when you're talking with the client so that you can let them know, hey, we're going to go and try to make it so that you do not have to go and appear as much as we possibly can to make this easy on you. So suppression hearing would be the next step if they're not willing to go and offer a reduction. A motion must be filed within 35 days from the date of the arraignment. Some courts are sticklers that that motion be filed timely, and you need to know how the caller's court approaches that. You don't want to be left with an objection from the prosecutor because you're filing out of time. If the caller refused, the suppression motion will address whether or not there was reasonable suspicion to pull the call over, whether there was probable cause to arrest the caller, and probable cause being based upon a totality of the circumstances, basically how the caller was driving, how they pulled over, how they looked, how they smelled, how they performed on the standardized roadside field sobriety tests, and whether or not the tests were demonstrated and instructed with substantial compliance with those standards. Again, you have the link to the NHTSA manual, you have the probable cause checklist, all of those things you would need to go and be able to do a suppression hearing, but in explaining it to them, the officer would have to come in, they would go and testify, client's not going to have to testify, and you would go and talk with them about that. And with respect to the breath test, whether or not the machine was calibrated properly, whether or not the certifications were proper, those types of things would be done in an OVI suppression hearing on a chemical test. And basically, if there's a chemical test, if there is a test, that's where the battle will be won and lost, because ultimately, if the judge finds that there was not reasonable suspicion or not probable cause, potentially the test goes away, substantially weakens the state's case. If the test is in, then that's pretty much it. You're not going to go and win many jury trials on a chemical test, because potentially they could go and just try the test on the case result, the per se, and not even deal with the impaired violation. And absent really specified factors, it's going to be very difficult to go and try that. If you don't have the chemical test, then if it's a refusal or the test gets broomed at a suppression hearing, the last step is a trial. And if you're not able to resolve the case favorably, or if the client prefers to litigate, a trial must be conducted, and that trial can be done to a judge or a jury. I prefer a jury. Some jurisdictions oddly go and do a lot of bench trials. I think Cincinnati, if I'm not mistaken, does a lot of that or favors that. I'm not sure why, but you need to know what your jurisdiction favors. Again, I think a jury trial is best. Given the choice, for me, jury trial is preferred, and the caller will inevitably want to know how long the trial will take, and you need to know how your jurisdiction approaches that. Some begin first thing in the morning, 8 o'clock, boom, knock it out all in one day, preferable. Others, like Franklin County, Columbus, Ohio, where we focus our practice, only do them in the afternoons after the morning docket is complete. So it's going to be 2, 3, 4 days, depending on how much you have to go and get into with respect to the trial. That's what it's going to go and take. And particular to the trial, if you're coming up on that, you're really going to go and do it, you can go and focus on the trial process itself, probably a conversation to be had at a later point in time. But you need to let them know, here is the process. This is what you're going to go through, and it is a process. And so ultimately, my time here with you guys is coming to an end. I hope that, this has been informative for you. And, my closing remarks are, again, you just really need to go and focus on the caller. And if you go and know the things that I was talking about, and you go and explain them and take the time to understand what the caller is going through, to be empathetic, to go and look to, from a practitioner standpoint, let them know what's going on from a salesmanship standpoint, go and look to provide that value, show that knowledge, that they go and trust you to go and handle what is the most important thing that's ever happened in their life, likely up to that point. It's going to give you a better chance to go and close that client. And at the end of the day, that's how we go and make our living. And I hope that you guys go and are able to go and use this presentation to go and help yourself make a better living. And again, please feel free to reach out if you have any questions or need anything. I'm always here. And I hope everybody has a happy holidays. Thanks so much.